So copy that, boom, paste it. There we go. Select here, boom. Oh. Title. I didn't know, whatever. Okay, so there we go. Now we do that. There we go. Okay, we are in live now for Group Quest 2. This is going to be the deep dive for the Blizzard lawsuit. Gulvan, you're here too.
Is this?
Yes, you are. Let's see. Let's start. Let's just press play. I don't want to get into
negotiation to say the settlement wasn't good enough. So the state of California has been looking at this issue and video games as an industry for some time. So this isn't quite the surprise that you might expect, but certainly some of the examples, some of the things that California alleges having happened at Activision Blizzard are eye-opening. On that note, we will be talking about things in this video that are probably uncomfortable for some of you and not great to hear about. I give you that warning so that you can skip that part. You can skip this video if you are so interested. The other in this space. Now, this was filed July 20th, so a couple of days ago. We can see it was filed by the Department of Fair Employment and Housing, an agency of the state of California, against Activision and its publishing, and Doe's 1 through 10, John Doe's 1 through 10, which we will see is effectively a reservation for the state of California identifying what appears to be executives, managers, people that work at Activision, that they can pin specific blame on certain events that they are claiming here and more that they might find through
and you better believe that those names have already been accounted for. They just did not put that in the report.
Which presents its own kind of problem when the state of California does name a few people that aren't otherwise able to provide.
Can you hear any of this
here? So we'll talk about that. We'll talk about
no,
but
I know where you're at.
Okay. How the state of California works, I can't blame you. The state of California has a department
right now on that YouTube video. I'm on 414,
that takes complaints 415, 416, 417. It's very easy to understand flowchart. The law ain't it grand that says, okay, you contact the department. Maybe they say, okay, you have the right to sue them, or they take in your form. They figure out whether they have jurisdiction over whatever it is you're complaining about. They accept your complaint. They investigate. And then when your investigation shows that a cause of action might have accrued, that the department actually has a violation that they want to pursue, yes, they enter mandatory mediation with that party, which we will see described in this lawsuit, which can either settle or, if it doesn't settle, might result in prosecution by the department in court, which is where we are right now.
So that means they knew about this ahead of time.
At that point,
so they lied completely about
or it
not
can
knowing
go through
about
the
it.
trial process and be adjudged by the court.
Well,
most cases everywhere on every topic
necessarily,
because at the end of the day, no one wants
as
to
far
pay
as
for
what
the
a public
legal
release
process,
goes.
lawyers, hey,
You
we're
don't
expensive,
want to
and
tell
else, only
everything.
to arrive at a place where
Well,
you're
no,
still paying
but I mean, they
somebody money, you're
knew
still in
because it
trouble
had to go through that
for
settlement
something.
first.
So most cases,
I didn't know
if the
about that,
parties
that it
can
had to go
have
through
a
mandatory
similar
mediation
in
before it even
concept
went
valuation
to
of what's
what we
happening
saw
in the
today.
particular case,
Right.
will settle because the legal process is expensive and time-consuming. And more importantly, for claims like this, if you're Activision, you would have to allow the department to go even further through your documents, through your compensation decisions, which are essentially
right now
the
everything's
black
going through
box
the old
of every decision making
Trump,
in every major corporation, and nobody wants the state or any regulatory body
divide and conquer
a company to have to go through that information because you
and
never
people
know
are,
what's going to pop out of
Blizzard's
the process.
making
So
people
settlement
choose sides.
is the most likely scenario, even after this lawsuit has been filed. But you can see through this process that there should have been mediation, and we will see Activision actually complain about that when we review their comment to IGN at the end of this video.
That's how I knew the IGN comment right there.
It says, headquartered in California since the 1970s, we're the nation's strongest anti-harassment, equal pay, and other equal employment opportunity protections exist for employees. Footnote 1, with a bunch of articles about how grand California is on this. defendants should be a safe haven workplace in the video gaming industry. Sexism has plagued the male-dominated gaming industry for decades, and increasingly so in recent years. And then they quote a bunch of articles. Feminist critics of video games facing threats in Gamergate campaign. Hello, YouTube reviewers. I did say the words Gamergate. I apologize. What is hashtag Gamergate and why are women being
that
threatened
didn't
about
happen.
video games? Dozens of women in gaming speak out about sexism and
Gamergate didn't
harassment.
happen.
The
No.
movement fighting back against sexual harassment in electronic sports. Now, you might look at that and say, well, actually, those are articles primarily about critics, people on Twitch, folks in esports that don't directly relate to the making of the video games, and you would be right there. You'd also be right to note that as far as complaints about discrimination and harassment at a given game publisher, this is actually neither here nor there. This is a paragraph, like so many introduction paragraphs we've seen in lawsuits, that isn't actually framing the lawsuit or the elements of the claim that the plaintiff here is going to make, as much as it's trying to set the ground for the tone that the reader of this document should understand this lawsuit is made in. Said another way, they are trying to establish that sexism, harassment, all this stuff is very bad. It's been in the video game industry for years, and so it should be no surprise to you, Your Honor, gentlemen and ladies of the jury, that this is a problem at Activision Blizzard. They continue, women and girls now make up almost half of gamers in America, but the gaming industry continues to cater to men. Even in California, Activision Blizzard's double-digit percentage growth, 10-figure annual revenues, and recent diversity marketing campaigns have unfortunately changed little. Defendants' compliance with California's broad workplace protections is long overdue. To enforce such compliance, the department brings this government enforcement action seeking to remedy, prevent, and deter defendants' violations of the state's civil rights and equal pay laws to vindicate the rights of defendants, female employees, and the public interest of the state of California. So this is an introduction paragraph. It doesn't say anything specific. We wouldn't expect it to. It does say video game industry is a problem in general, and we are taking this action
Which is
as
true.
an agency of the state
Video
to
game
vindicate
industry
most
is a problem in
specifically
general.
defendants' female employees. And we'll see as we read through this lawsuit that this amounts to a class action. They'll use the term capital G for group to indicate that they are trying to ask for damages and protections and everything else for what they describe as every aggrieved woman at Activision Blizzard. And that presents a potential problem because rather than just fighting over one specific set of circumstances, they're going to have to show that there's a systemic institutional issue at Activision Blizzard that's going to be quite difficult and isn't done in this complaint because you can't really do it in a complaint like this. So they give examples that are not going to rise to the level of winning the case for them as of this time, but are going to rise to the level, in my opinion, of course, that will defeat a summary dismissal. It's well pled. It's a document that's going to get them past that process and is going to put Activision on its back foot to either settle, to avoid discovery, or to get everything ready for a big, messy litigation. And a couple of points here. They describe Activision Blizzard, headquartered in California, as one of America's largest video game developers and distributors with approximately 9,500 employees and over 100 million players worldwide. That number is important. This is a big company. So one of the other things that California is facing here is that just having 3, 4, 5, 7 incidents of problems at the company out of 9,500 employees might again not rise to the level of systemic issues. The state of California has to come in here and establish in a case like this one, brought as a class action against the company itself, that they have pervasive problems across their company, that they turned a blind eye, that they rejected reasonable steps to prevent those problems, and they can make that case. One thing I want to say, as you probably saw at the top of my thread, is everything here is important. These are serious complaints. They deserve to be taken seriously. When you hear me talk about some of the issues, some of the hurdles that California will have to jump over, that is not to say that they can't. That is not to say that they can't win their case. It is to suggest, however, that it's not the slam dunk that it might appear to be, and that if Activision decides to go to the mattresses and fight this thing fully with its legal power, you can expect things to get pretty heated, as we already saw in their response to IGN, which, in my opinion, was probably ill-advised. We'll get to that. It's not terribly genteel in tone, especially to the state, but it does suggest that there are passions and emotions running high, probably from both sides, California and Activision, and in those circumstances, that's when you get the very rare, huge bet the company type litigation, and that could happen here. Unlike its customer base of increasingly diverse players, defendants' workforce is only about 20% women. Its top leadership is also exclusively male and white. And again, that's neither here nor there for the complaint in this document. The CEO and president roles are now, and have always been, held by white men. Very few women ever reach top roles at the company. The women who do reach higher roles earn less salary, incentive pay, and total compensation than their male peers, as evidenced in defendants' own records. And here's
Look how
where
much
we
Kodak
start to see
actually
California,
makes.
in my opinion, of course, making a misstep, a significant one. First, we see that unlike the reporting at IGN, California isn't opening up with the harassment complaints. In fact, the harassment complaints, which are what is being reported on most often that I have seen in gaming journalism outlets, are not the focus of this complaint. The focus of this complaint is discrimination, which we'll take a look at. And one of the most significant points, which is the first thing that they bring up here,
that is a problem.
Discrimination in pay. And they use as evidence, and they use a lot of space in this actual document, which isn't so long, their proxy statement to the SEC that says the following. Bobby Kotick makes $154 million. He's the chief executive officer. Dennis Durkin makes $13 million. He's the chief financial officer. Daniel Allegrieri makes $13 million. Claudine Naughton, which is the only identifiable female name on this list, the chief people officer, only makes $4 million or so. And Chris B. Walther, which we can see here is actually the lawyer, makes about $3 million or so. And they are using this to, again, establish that the women who do reach higher roles, like chief people officer, make less than their male peers. The primary problem with this complaint, as you might have already adduced, is that chief people officer is not chief executive officer, is not chief financial officer, is not chief legal officer, is not chief operating officer. CEO is responsible for the strategy of the company. CFO is responsible for the money. COO is responsible for the day-to-day tactician type stuff at a company. The lawyer is the lawyer, and the chief people officer, very important role, worth $4 million, is responsible for human resources, for the processes and procedures that go along with human resources, and ideally would be one of the people that would be named as responsible for the problems that are put in this particular complaint, except that as a woman, I can't imagine that that's actually what the state of California intends here, and especially because they're using her as an example of not getting enough pay. Now, obviously, Bobby Kotick's pay has been in the news. It's not $13 million. It's $155 million, and that's worthy of consideration. But when we're looking at legal elements of a case, and what you have to show is that women are treated differently than men, making the same kind of job decisions, doing the same kind of things, this is a terrible, terrible example of that. And that's a bad foot for California to start on because it doesn't prove their point. It will be very easy for Activision to smack down, even if you hate Activision. Like the executive ranks, California continues, women across the company are assigned to lower paid and lower opportunity levels. Now, we want to pay attention to that.
That would be
because,
very
again,
easy for Activision to strike down.
Is really pushing hard
the
on
money part.
Is that Activision as an institution has a bias against women, and that bias is manifested in terminating them more often, in paying them less, and in doing those kinds of things. Probably refusal to hire, although it's not articulated terribly well in this document. And one of the things that California tries to elide and kind of skip as part of this complaint is the notion that different people might be at different roles, might have different work, might have different merit attached to what it is that they are doing. And California presents some examples that are pretty clearly problematic from the Activision side on equal pay. But as an overall kind of thesis, having been assigned to lower paid and lower opportunity levels sounds, if you're so generous to Activision, like people that are hired for different roles and different jobs. And to the extent that they are, the state of California tries to combine female counterparts and male counterparts in a way that might be defeatable by Activision when it actually comes to presenting their case, because there are so many different types of jobs. There are so many different types of cities that Activision actually operates in, and that could be a thorn in California's side here. Female employees receive lower starting pay and also earn less than male employees for substantially similar work, and that would be a problem. That's the assertion here, the magic incantation that would result in a problem for Activision. But California kind of elides what exactly it means by substantially similar work. Defendants promote women more slowly and terminate them more quickly than their male counterparts. Faced with such adverse terms and conditions of employment, many women have been forced to leave the company. They're going to present a constructive termination case here as part of this particular complaint that says, hey, if we make it bad enough for you, it's like we fired you, which is the problem, and which is perfectly well pled as far as I can see in this document. Then we get into kind of combining that discrimination idea with a harassment idea, and this is what was reported on. This is the lasciviousness. This is the stuff that's newsworthy for a lot of publications. It's what IGN went out with in their headline. Defendants have also fostered a pervasive frat boy workplace culture that continues to thrive. In the office, women are subjected to cube crawls, in which male employees drink copious amounts of alcohol as they crawl their way through various cubicles in the office, and often engage in inappropriate behavior towards female employees. All of this is bad. Can't honestly recommend drinking events in companies. However, we have to dive deep into this and say, okay, so if you've got a cube crawl, is it really that only men can drink and the women are at the cubes? What does this actually look like in practice? And again, because this is the complaint, California doesn't have to present that defensive evidence. We wouldn't expect them to. But when we read through one of these, anybody can write whatever they want in a complaint, and we have to read through them and say, okay, is this exactly what is happening here? Obviously, a very bad idea. Can't recommend it because it looks like this. And it also looks like this when faced with discrimination charges, which are the bulk of what the state of California actually offers here. Male employees proudly come into work hungover, play video games for long periods of time during work while delegating their responsibilities to female employees, engage in banter about their sexual encounters, talk openly about female bodies, and joke about rape. All of which is horrible, with one exception, possibly, which is that you'll see the state of California use this play video games, play Call of Duty a lot in this document without actually referencing the fact that Activision Blizzard makes Call of Duty, makes video games, that there are legitimate reasons why someone in a given role could play video games at the office in this particular job. So while it looks terrible if, say, somebody at Hogue Law is just sitting around playing video games when they should be doing work, it doesn't look nearly the same for someone that's doing competitive analysis on a design that they're making at Activision.
Those people will be doing work because they're playing video games.
What they should adopt for their own games. So
and that's a point there too.
Absolutely terrible when you read all of this, and it should be something that is looked at very carefully by the state. This is serious, and Activision should be stopping things like jokes about rape in the workplace, but we have to take it with a grain of salt because this is the complaint that's trying to establish this in the first instance. Unsurprisingly, defendants' frat boy culture is a breeding ground for harassment and discrimination against women. Now, as I just said, harassment and discrimination are different. We're going to come back to that in just a second as we look at how the state defines these things. Female employees are subjected to constant sexual harassment, including having to continually fend off unwanted sexual comments and advances by their male coworkers and supervisors, and being groped at the cube crawls and other company events, which sounds absolutely awful. High-ranking executives and creators engaged in blatant sexual harassment without repercussions. In a particularly tragic example, a female employee
I think after the segment's done, I want to skip to 28:15.
With a male supervisor who had brought sexual equipment with him on the trip. Defendants continuously condone the quid pro quo and hostile work environment. The message is not lost on their employees. And we'll get to these harassment examples, and I'm going to try to avoid using some of the more lascivious comments if I can. Numerous complaints about unlawful harassment, discrimination, and retaliation were made to defendants' human resources personnel and executives, including to Blizzard Entertainment's president.
When this
but
segment's
defendants
over.
failed to take effective remedial measures in response to these complaints. It's one of the reasons why you present these examples, is you can say to the court, you say, hey, if these examples exist, if they continue to exist, even if they're fairly occasional, then it's clear that the company isn't doing enough to stop them. The problem is, no company can be perfect. Even the state of California understands that. So what's required are reasonable measures to try to stop these things. And somebody could have been a saint for 20 years and decide to go off the deep end and do something bad. And if you take proper actions at that time, then you probably, as an employer, shouldn't be held legally liable for that because you've done all that you can, and human beings are human beings. But if it's systemic, if there are all these examples and the state of California believes that it is, then yeah, Activision should be liable for these kinds of things.
And should
Employees were further discouraged from complaining as human resource personnel were known to be close to alleged harassers. An internal investigation of the Human Resource Unit noted that there was a big lack of trust and that HR is not held in high regard. And having worked in big business and companies for a long time, I'm not sure that HR is held in high regard at a lot of locations. Leave a comment if you love your HR department. But I don't view that as significant for a legal complaint of this type, although if you do have continued issues with this, your HR has to be someplace where employees can go. So it's kind of a
and never is. HR never is anymore.
Problem, but I
HR
don't know that
is
just
what
saying
we know
HR
it is
held in
gone.
high regard actually proves the point California is trying to make here. Unsurprisingly, employees' complaints were treated in a perfunctory and dismissive manner and not kept confidential, which is bad. As a result of these complaints, female employees were subjected to retaliation, including but not limited to being deprived of work on projects, unwillingly transferred to different units, and selected for layoffs. Again, if you complain to HR about something serious and this happens to you, that is, again, illegal in the state of California. We'll take a look at the elements of that as well. The Plaintiff Department, an agency of the state of California, brings this enforcement action against defendants in its prosecutorial role, seeking relief in the public interest for the state and for defendants' female employees, the capital G group. Pursuant to the authority vested in the department under the government codes, the department enforcement action seeks to remedy, prevent, and deter unlawful harassment, retaliation, and discrimination. Specifically, the violations pled herein include claims for sex discrimination in terms and condition of employment, compensation, assignment, promotion, constructive discharge, and termination, harassment, retaliation, failure to prevent all those things, and unequal pay.
All right.
That's just the introduction. We're not going to read through every
Here we go.
Skip ahead. On October 29th, 2018, an amended complaint was filed and served to add Activision Blizzard. December 7th, there were more complaints. After more than 2 years of investigation, the department issued a cause finding on June 21st, 2021, so less than a month ago. In the course of the investigation, the department found evidence that defendants discriminated against female employees in terms and conditions of employment, including compensation, assignment, promotion, termination, constructive discharge.
Yeah, so it wasn't just like a
also found sexual
all of a sudden lawsuit,
and found that the defendants Activision failed to take reasonable steps to prevent those things. The department says they attempted to resolve this matter without litigation, as is required by the laws that we've read as part of this video. Prior to filing this civil action, the department required all parties to participate in mandatory dispute resolution in the department's internal dispute resolution division free of charge to the parties in an effort to resolve the dispute without litigation. Specifically, the department invited the defendants to participate in a mediation session with the department's internal dispute resolution division
because he left in
July
2018.
1st, 2nd, and 15. But the parties were unable to resolve the administrative complaints. Then they talk about the rest of the law. If you're unable to solve it, then you can file a lawsuit. And because you might have noted that that's
not
more
with
than
the
2
action that
years
he
old,
is talking about right now.
Paragraph 22.
The one that he is
says,
talking about right now was done a month ago.
Parties, the department's deadline to file a civil complaint is July 21st.
Okay. No, I mean the original
the department
filing of the allegations.
In fact, 1 day.
Said 2018 is when it was originally was sent.
Just administratively,
right?
You shouldn't get anybody out of the very serious allegations
but even
that are made
Moorheim had acknowledged that
to me, not a
this stuff was
lawyer.
going on.
California litigator, if they want to pop into the comments, can definitely talk about.
Well,
this
I mean, maybe he was pushed out because he was trying to
party can waive
settle or something. Like he was agreeing with them.
Statute of limitations here.
What's that?
Because statutes of limitations primarily exist.
Like I'm saying is like maybe he was pushed out by Activision because he was agreeing that it happened.
We did think that.
And here to make
sure but maybe this is the article that was like the final one for Activision because he was going to go along with it and not join them but be cooperative.
Has to be brought within 2 years of filing. And I looked at
the
the
I think
laws.
all indications at that time
was this could be waived by one of the parties here. Perhaps
he was being moved aside.
People could direct me to. It's again a technical
by
legal issue.
by
it's not
Activision,
necessarily
and
an
I
issue
think
that
he just said, you know what, I'll just
waiver
retire.
Isn't permitted.
Instead of being moved
waiver
aside,
might not be permitted, and it depends on the state,
you'll let J. Allen Brack
and the
come on in,
and the precedents and things that California lawyers
and J. Allen Brack inherited the mess.
In this particular circumstance, you have a situation where the state of California can say, "You're going to extend this, or we're going to do very bad things to you right now. We're going to sue you as it stands right this second. We're going to make your life miserable." And so this signature is given by duress, and it shouldn't be because 2 years is what's set forth in the statute, et cetera, et cetera. We don't know the circumstances there. Right now, we can assume that Blizzard Activision was sophisticated. They were perfectly within their powers and understanding to give what amounts to an extension or a waiver of the statute of limitations to the department. And the department took that extension and sued them, I think, pretty close to 3 years after we're talking about the original complaints that have been made. Just kind of a sidebar, but an interesting one, because what this case winds up looking like to me is the stick that would have been used in this mediation process. And what I mean by that is, you go into mediation, you're the state of California, and you say, we want $500 million. And I use that number basically because they say Riot should have to pay $400 million. They weren't actually a party to that. But they say, we want $500 million. Activision says that's ridiculous. We've got policies. Yes, we've made mistakes. We're not owe somebody $500 million for these purposes. State says, yes, we think that you do. And they say it again on the 1st, the 2nd, and 15th. And on the 15th, they say, look, you don't give us this or something else that Activision thinks is completely unwarranted and untoward, then we're just going to file a lawsuit against you. And we'll see Activision complain about this process at the end of the video. But this is the kind of thing that if you're a government body or an agency or a prosecutor, you see all the time. If you don't agree to X, we're going to make your life a living hell. In this case, we're going to bring this complaint. And Activision has called into question the good faith process that the state of California has used here. We can't speak to that because just like the complaint actually asserts, all of that is fact dependent. We don't know what happened in that mediation. We don't know whether the state of California acted as angels and offered Activision a get out of jail free card for $1. We don't know what was said in those things because they're confidential and for good reason. But we know that Activision's complaining about it vociferously. And we know that the state of California feels like they met their legal burden. If they didn't, this is the kind of place where a lawsuit of this type could short circuit, where a court could say, we don't think that you actually entered into these mediations in good faith. Go back to the table, do that kind of thing, and then come back to us.
We'll hit the next 10 minutes. We don't need to hit the examples where they got that.
A problem. The department brings this government
examples of harassment. We can get right back.
On behalf of itself and the public interest, the state of California isn't interested in having harassing companies in its jurisdiction and discriminating companies in its jurisdiction. That makes total sense. And all aggrieved female employees, the group. It's a class action. We continue on through this kind of procedural stance to get to the factual allegations. And we'll note here, this is on page 11. By the time you get to page 16, you're already talking about the counts. So I want to leave that in a kind of unusual step here for the end. We'll come back to page 11. We'll talk about the facts. We'll talk about why they really do raise concerns. Nobody wants to work for a place with some of the stuff that is alleged in those particular data points. But I wanted to talk about the actual causes of action here because I think it's useful to talk about the legal landscape before we talk about the stuff that is likely, as it did for me, to raise your emotional ire at some of the things that are alleged here. So the first cause of action, as we talked about, is about compensation. We see this 12940, as we just talked about in the jury instructions, 12940A, this particular law that talks generally about discrimination, is the one that's brought up at the top of almost all these counts. It says defendants intentionally discriminate against women in compensation. For example, defendants offered women lower compensation at hire, assigned them to lower paid and less opportunity levels and roles, awarded them less incentive pay and or equity pay opportunities, and afforded them less advancement and other opportunities than their male counterparts. And counterparts is doing so much of the heavy lifting here. Because again, when we talk about discrimination, it's on the concept that people are doing the same thing. No one should expect, if you are the chief people officer, to get the same as the chief executive officer. And that goes along all the way through a hierarchy of a corporation. When you combine that with kind of merit analysis, what the state actually has to show is that they were doing the same thing, or perhaps ideally for the state of California, that the woman was doing something better.
That's the entire point.
Nonetheless, did bad things to that person, and they have to show.
If someone was doing the same job as what you were, or as what you are, Gulvan,
policies, practices,
as what I am,
that's the system that they have
for the same amount of years,
have resulted in unlawful, disparate
should they not be
discrimination
paid the
against
same
women with respect to compensation opportunities? That the way
and that's really the
way
argument
their policies operate, what they allow, what they don't,
what these people are trying to make,
resulted in a system of depressing
as far as what that goes.
Female pay at Activision
If
Blizzard.
they can't make that argument,
for example, defendants offered women lower compensation and higher.
There's
we'll get the same examples here. As a result, defendants' unlawful employment
there's
practices
no argument there.
Suffered and continue to suffer.
The argument would
including,
go right into
earnings, lost benefits, lost
the whole sexual
acts and other
acts.
financial loss. As I said, this one is easy to prove in respect.
And not in the fair pay
defendants'
argument.
actions demonstrate that they will continue to engage in this pattern and practice of unlawful employment discrimination. So we have a reason, court, jury, to ask for you to stop these things. And defendants' actions were willful, malicious, fraudulent, and oppressive, and were committed with the wrongful intent to injure female employees in conscious disregard of their rights. That's a heck of a thing to allege, right? I think if we were being generous,
I'm up to alleged causes of action.
Else that's caught in these kinds of discussions,
what
you
time
could
are you
say,
on?
36,
hey,
35.
we've got a subconscious bias, and we're very sorry about that. We're going to correct it. State of California here is alleging that they are intending to do this bad thing as an institution against women. And that's going to be a hard thing to prove. That's one of the reasons you go into discovery. You're looking for emails that are subject heading, let's depress women's salaries, and Bobby Kotick responding with a, ha-ha, yes, let's do that meme. And that's going to be tough to find. But if you get into the willful, fraudulent, and oppressive bucket, then you get higher fees, you get bigger penalties in every state, and one presumes in California as well. Unless the defendants are enjoined, unless a court prevents them from continuing to do this, female employees' right to seek or hold employment free of unlawful discrimination will continue to be violated by reason of the continuous nature of defendants' unlawful conduct. The continuing violations doctrine is applicable to all violations alleged herein, meaning they still are alive for purposes of a court to make a determination here. And here's where you see the state of California has really reached far. And we don't know where its grasp ends because these kinds of things are so fact dependent. It matters what pages 11 to 16 say, and we'll get to those after we talk about the counts. But they have alleged that it's institutional, it's systemic. The practices, the policies have resulted in all these things, that everything is continuing, that we should get an enjoined status from the court to actually prevent them from continuing to do these things. And we did it primarily with anecdotal and data point-driven examples. Then you get the same kind of complaint on all the other grounds that they talked about in the introduction paragraph. That was compensation. Here's promotion. And we see defendants intentionally discriminate against women in promotion and advancement opportunities, for example, and the same kind of thing. Defendants assign women to the lower paid and lower opportunity levels and roles, delayed their career advancement, denied them promotion.
Promotion goes to people that deserve it.
And refuse to promote women because
that
they might
should
get
not matter.
Even when women perform
woman, man, black, white, whatever.
Periods of time.
Promotion goes to people that deserve
than
it.
This kind of counterpart language. Higher level work for extended periods of time is where you can get into trouble. And if the state of California can
I don't
prove
think
that starts to make their case significantly stronger.
I don't think that
then
the
we have
plaintiff
disparate
has
impact,
any
else,
argument there.
Practices, defendants' quota system, which isn't described as far as I could see in this complaint, lack of application process for promotional opportunities, as well as its informal and opaque decision-making process, resulted in female employees being promoted at slower rates than their male counterparts. This is a weird assertion because this is, like we saw with policies and procedures, a statement from the state of California that Activision has to comport its internal decision-making in a specific way. And that's always going to be a little bit harder than just stating that it's discriminatory on its disparate impact basis. In the state of California, I suspect that could find some purchase, that they might have some luck with a claim like this, because the state of California really is a very aggressive state in making these determinations for corporations within their jurisdiction. But like the other complaint parts that we've seen and discussed already, this is the kind of thing that California is going to have to spend some time proving and showing to a court. As a result, they suffer harm. They'll continue to do it. It was willful, malicious, and fraudulent. They have to be enjoined. And then we get to the third cause of action, termination. And we get the same kind of thing. Defendants' policies, practices, and procedures have resulted in unlawful, disparate impact discrimination with respect to termination. And it caused them harm because they don't have a job anymore. It was willful, etc. Constructive discharge. Defendants constructively discharged women in violation of the discrimination code. For example, in denying women promotions, assignments, and compensation in comparison to their male counterparts and subjecting them to sexual harassment and hostile work environment, defendants effectively forced female employees to leave their employment with defendants. Now, they try to drag in harassment here in a way that I don't know will work in California, because when we actually go and we look at what is happening with harassment, we see that a harassment claim is about conduct that is severe and persuasive, that is hostile, intimidating, offensive, oppressive, or abusive. And more specifically, if we look at the definitions that are often provided to juries and where they come from, that are distinct from discrimination. We have here a quote from a case in California. We conclude that the legislature intended that commonly necessary personnel management actions, such as hiring and firing, job or project assignments, office or workstation assignments, promotion or demotion, performance evaluations, the provision of support, the assignment or non-assignment of supervisory functions, deciding who will and who will not attend meetings, deciding who will be laid off, and the like, do not come within the meaning of harassment. Harassment, by contrast, consists of actions outside the scope of job duties, which are not of a type necessary to business and personnel management. Now note, that doesn't mean that you can't bring a claim for both, as we see in front of us, but also as reported on by the California courts. We can discern no reason why an employee who is the victim of discrimination based on some official action of the employer cannot also be the victim of harassment by a supervisor for abusive messages that create a hostile working environment. And under the governmental code, the employee would have two separate claims of injury. Baking it into a constructive discharge complaint is potentially problematic, but it might work in California. The point is that this is discrimination that they tie into the harassment, where a lot of their examples are more eye-opening and potentially more significant to jury members that are going to be susceptible to having their eyes open in the ways that I think some people that have reported on this and that have read those reports have had happen in the past 24 hours or so.
Yeah, and we would agree with that.
Constructive discharge action, we get to the fifth cause of action, which is harassment. As we just talked about when reading through the jury instructions, harassment is distinct from discrimination, but it is an important separate cause of action, and I think it's the one that really has raised those eyebrows that I was just mentioning. In fact, as we talked about, IGN only reported basically on the harassment, the frat boy culture, and sexual harassment. And as this lawsuit brings up, it says defendants' female employees were routinely subjected to unwelcome sexual advancements and other harassing conduct. The harassment was perpetuated by defendants' supervisors and or defendants knew or should have known of the conduct and failed to take immediate and appropriate corrective action. As a result, female employees suffered and continue to suffer harm, including but not limited to emotional pain, humiliation, embarrassment, belittlement, sadness, and mental anguish in an amount to be determined at trial. And defendants was willful, malicious, and it's continuing, and need to help us out court by actually enjoining them from being able to do these things on a continuing basis. So we see harassment is only a part. It's only the fifth cause of action.
Then we'll jump up to one.
In connection with a couple of things. So we saw the discrimination about pay and termination and promotion and constructive discharge.
Yeah, we'll go up to 102.
Harassment. Now we see retaliation brought
1 hour,
as a
2
separate
minutes.
cause of action. And we go and we look at retaliation, if I can pull up the right one, and we see this is a similar kind of concept. It says the plaintiff was doing something protected, something like talking to HR about potentially illegal activity happening at their employer, and that the plaintiff was then discharged, demoted, had something else bad happen to them by virtue of Activision deciding to do it. The plaintiff's protected activity, talking to HR, causing trouble for Activision, was a substantial motivating reason for Activision deciding to do those things, and that the plaintiff was harmed because Activision decided to do those things. But the other thing that we would point out is that one of the things that you can bring against a company in California is this failure to prevent harassment, discrimination, or retaliation. We see the name of defendant failed to take all reasonable steps to prevent harassment, discrimination, and retaliation is a separate legal action and is part of a package that we would expect to see as what amounts to kind of a boilerplate package from the state of California or even from civil complainants that says, okay, if we're going to bring a complaint that you're underpaying women, that we've got some cases where you've got cube crawls, you got all this other bad stuff, some of which we're going to talk about towards the end of this video, then we can bring a complaint for harassment, we can bring a complaint for discrimination, we can bring a complaint for retaliation, and then that all gets baked into failure to prevent harassment, discrimination, or retaliation. So if we look at the lawsuit, we'd expect that to be the next cause of action, and indeed it is. Failure to prevent discrimination and harassment on behalf of the group, the women that the department is bringing it on, and another cause of action on behalf of the department itself because the state of California doesn't want this. Then we get the ninth cause of action, which is unequal pay, which really ties into the first cause of action about discrimination on the basis of payment. And we get a 10th cause of action, which really isn't measured in the introduction.
And once again, the whole thing of pay is going to be very, very tough for
continued employment, bonuses, raises
prove
on a general release document, something that would say
but if they stick to sexual harassment,
Activision from all prior complaints that they might have
and
against
I think that's
it,
what a jury is going to listen to.
Law.
Oh,
now,
boy.
as I've mentioned a couple times, I'm not a California lawyer. This is one of those places where California has stricter rules than a lot of the states in the United States. It's very common for me to see when I'm doing my work here in Michigan or elsewhere a document that says you're going to get this thing employee, you're going to get this thing manager, whatever else it might be, as long as we have a mutual release of claims that both sides agree that we're not going to sue each other on anything that happened before this time. And actually acts as a bit of a settlement if there was ever anything that could have potentially given rise to a complaint in a state or federal court. And those releases are not all that unusual. But in the state of California, as asserted by the state of California, they are illegal. So when Activision was asking for those things, they had their own separate cause of action that can be brought against them for asking employees to give up certain rights, which California says they aren't allowed to give up. Now, it'll be interesting to see where that one goes. Again, very fact-dependent. What is Activision asking people to do? What are the rules in California? And then we get the prayer for relief, which is, hey, we want money, we want unpaid wages, we want the court to say you can't do this, we want the court to establish that Activision did something wrong, we want interest, we want attorney's fees, we want everything else the court wants to give us, and we want it to be adjudicated in front of a jury. Why do they want it in front of a jury? Well, because there are a lot of emotional claims here. And I don't blame the state of California for this at all, But juries are going to be more susceptible than a judge who sees these things a little bit more often than those jury members to thinking about these things, thinking about how they would react if their mother, their sister, their daughter were in this position. And that's a smart play by the state of California.
All right, let's skip up to 1
I would expect them to get
hour,
that jury
2
trial
minutes.
as part of this. If it goes stronger, the state of California brings all the things that you've seen reported on everywhere. This is the sexual harassment place of the case. I'm going to try to avoid most of the stuff that is descriptive.
All the examples,
and that's
not
to
all the
cushion
examples
the blows from
that
Activision. That's basically to try to prevent Google and YouTube from just throwing this video under the bus. But you can absolutely check out the document. It will be linked in the description. We'll talk about some of this stuff, and some of this sounds absolutely repugnant. Female employees almost universally confirmed that working for defendants was akin to working in a frat house, which invariably involved male employees drinking and subjecting female employees to sexual harassment with no repercussion. This sounds
an easy fix
like
there.
what we've seen in the video game
ban
industry,
alcohol
Ubisoft,
from the
whether it's
workplace.
Riot, other complaints that we have seen in the recent past. The state of California knows that, and if it is true, it's horrible. And I would not expect this from any industry participant in 2021 in any industry. And if this is in fact happening, then the sexual harassment component here is entirely necessary and should be looked at with a great deal of seriousness by the state, by people that look at Activision, by Activision itself, obviously. Cube crawls in defendants' offices were common, and male employees proudly came into work hungover. Similarly, male employees would play video games during work, engage in banter about their sexual encounters, talk openly about female bodies, and make numerous jokes about rape. As a product of this frat boy culture, women were subjected to numerous sexual comments and advances, groping, and unwanted physical touching, and other forms of harassment. A female employee noted that random male employees would approach her on defendant's work site and comment on her breasts. Female employees working for the World of Warcraft team noted that male employees and supervisors would hit on them, make derogatory comments about rape, and otherwise engage in demeaning behavior. This behavior was known to supervisors and encouraged by them, including a male supervisor openly encouraging a male subordinate to buy a prostitute to cure his bad mood. Yeah, none of that's good. None of that's good at all, and it's exactly the kind of thing that sexual harassment laws are designed to prevent at a foundational level. Then you get into the state being
if that was done anyplace else,
strategic in a way that I find objectionable. And we're going to try to
that supervisor would be fired
because I can't actually modify this particular document here. But one of the things that they do is that they call out the behavior of a specific person operating at Blizzard.
I know that for a fact because one of my supervisors, plant manager, was fired there when I was on vacation.
Not having an opportunity to defend himself.
They,
I'm not saying
they didn't pull stuff up on this.
I am saying that
this
when
matter
bring a public
this
document like this that's going to be reported on, you know it's going to be reported on. That's
still,
why you wrote it the way that
it had to be serious enough crap
when you're talking about mediation.
in order for him to be fired, and it was. I'm not going to get into what he did.
That raises a problem for me because that
but
person
he did deserve it, and he
court.
got it.
And if you're not going to use even allegedly, if you're not going to just use the job title, that is a significant issue. Now, we don't know exactly whether this person has some kind of settlement with the department that would indicate that they don't have to use allegedly or something along those lines, but as far as we can see from the outside, it's really going a step too far from my perspective for the state to do these kinds of things. And the state really has to be based around justice and fundamental fairness principles. And this kind of broaches that line. Now, without kind of discussing the names here, we do see that they have that this individual is blatant sexual harassment with little to no repercussions. They're using it as an example for how Blizzard failed to address these kinds of issues. And says that they got a slap on a wrist from the president.
And Jay Allen Breck
is
in
that. Blizzard, not Activision Blizzard. And so what we've got is cube crawls,
named in that,
which are universally
sexual harassment
confirmed.
part.
We've got a specific individual which is named, and then we've got this suicide. And you'll note that the state of California, which we are going to describe here, so skip ahead a minute or two if you don't want to hear about it, actually couches itself very, very differently than it did with the immediately prior paragraph that talks about somebody doing very bad things. This says, in a tragic example of the harassment that defendants allowed to fester in their offices, a female employee committed suicide while on a company trip due to a sexual relationship that she had been having with her male supervisor. Now, it's unclear exactly how the state of California knows precisely what the suicide was due to. The male supervisor was found by police to have brought sex toys on the business trip. Another employee confirmed that the deceased female employee may have been suffering from other sexual harassment at work prior to her death. specifically at a holiday party where male coworkers were alleged to be passing around nude pictures of her. And you could see that couching, right? So we've got, this is happening
not
because
just
of the
of
sexual
her,
relationship.
but of her
male
private
supervisor
parts.
Brought sex toys, and then another employee, singular, confirmed that they may have been
How
suffering
is this
other
acceptable
sexual harassment
in the
for
workplace?
the alleged passing around
It isn't,
photos, which
but
we
that's
can
just how
read
it
to
is
mean
in
that the
those
state
things,
doesn't actually have
unfortunately.
any evidence.
When the
of this. They
higher
have
ups are the
testimony
ones
from
that
one
are in
person,
charge,
and they use
and they're the ones
may
doing
and
the
alleged and all
behavior.
that here, and then they actually say that this suicide happened.
That is
due
what
to
is
the
going
sexual
on
relationship.
within
All
the
of this is
gaming
horrible.
industry.
All of this is terrible. And if it is in fact due to all these things, Activision needs to be punished, needs to look at its policies, procedures, needs to look at who it hires, needs to look at how it handles things. And I don't want to minimize that aspect of this at all. What I do want to say is that Activision will respond very strongly to that particular paragraph in their response to IGN, and that the state of California doesn't actually make the connection between the sexual relationship, which you shouldn't be having between supervisors and supervisees anyway, and the suicide, as well as the other components which are used by apparently one person's testimony. So that's it for harassment. That's what you've seen in all these various articles, and they're very, very bad, and they should be looked at, and the states should look at these things. California, Michigan, wherever you are. But
yes,
whether or not that's a systemic problem, or whether or not that's one bad apple or 2 or 4 out of 9,500 is going to be a part of the case. And that's going to be an important part of the case when talking about things from a legal perspective. Then you get the retaliation and defendant's failure to prevent all these various things that we saw as part of the counts. We see that the company itself didn't respond to complaints as alleged by the state of California.
Activision's response, and
we'll end it. HR was not held in
after
high
we
regard,
hear Activision's response.
The defendant's flaws, all of Activision's flaws, essentially allowed all of these things to continue. But again, we have 2 paragraphs here. We don't even have specific anecdotes. So you get to the end of all this, and you've got a lawsuit that makes headlines. It'll probably appear in every single gaming outlet. It obviously appears here in Virtual Legality because it's a gaming lawsuit. This is what we talk about here. We talked about it for more than an hour now. But it's an important one because everything you're hearing about
that's what
this
he
company,
talks
if it's
about.
100% true. If the state of California is right that Activision Blizzard was doing this specifically, oppressively, maliciously, then they deserve the book to be thrown at them. But as it stands right now, you've got a complaint document which is designed to make you think that before any counter complaint or other defense is presented by Activision Blizzard. And what you've got it premised around are anecdotes, data points. Or as I said in this Twitter thread that I put up last night, effectively, they're anecdotal. And while bad if proven true, and undoubtedly bad, terribly bad, they don't themselves rise to showing a systemic issue, which anecdotal data points really can't. You can't take data points and pluck them from here and there and then say this proves an institutional issue, especially when you're talking about 9,500 people in multiple offices.
And
that
there's
doesn't mean,
a
as I say here,
potential
California
problem
can't
right
prove
there.
the case, but it does mean they have to do a lot more. And if it continues, it's going to get messy, or it's going to settle pretty quickly. Now, my money is always on settlement in cases like this because Activision Blizzard doesn't have any idea what skeletons are in all of its closets. It's too big of an institution, and you don't want the state of California or the
Blizzard knows what skeletons are in its closet. Activision does not know what skeletons
because something will be there.
In
There's something
all
in
of
every
the closets.
And you don't know what that'll look like, and you try to avoid it.
What is in all the
because
closets.
ugly stuff will come out, ugly stuff will get leaked, it'll be in more articles, it'll cause more damage to your company and to your brand. And that's what the state of California is counting on. And not wrongly so, especially if Activision is in fact responsible, as California suggests. But Activision does know that they are getting pressured here, that they're getting leveraged here. And while I think this is the tonally incorrect way to respond to an issue like this, you can, if you are generous to Activision, and imagine that California is taking a couple of bad apples and a couple of bad stories and railroading Activision to make a point, come to a similar status as Activision does here that says California is acting incorrectly. But let's take a look at what they actually said. Activision Blizzard says, "We value diversity and strive to foster a workplace that offers inclusivity for everyone. There is no place in our company or industry or any industry for sexual misconduct or harassment of any kind. We take every allegation seriously and investigate all claims. In cases related to misconduct, action was taken to address the issue." That's not part of the complaint. We don't know what action was taken. We do know that one of the paragraphs they mentioned a specific individual, that individual is no longer working for Activision Blizzard. And we don't know the entire story there. And to bring it up in that particular context is suggestive of Activision Blizzard not doing enough, but it's unclear exactly what Activision Blizzard can do once a bad thing happens, if it's against their policies and they investigate it and they terminate the person, what it is that they should do. So we've got different approaches to these specific facts, and this will be a factual inquiry. Continuing with Activision Blizzard's response, the department includes distorted and in many cases false descriptions of Blizzard's past. And they are accusing California of lying, which of course, if they were, adds an entirely different wrinkle to all of these things. As I've said, they definitely take certain ambiguities in the language that they're using about hiring people for different roles, whether they are in fact counterparts, what equal pay means in the way that they have used it to describe it. We've been extremely cooperative with the department throughout their investigation, including providing them with extensive data and ample documentation, but they refuse to inform us what issues they perceived. Now, that's an interesting accusation, right? When we go back to the law, if the department determines after investigation that the complaint is valid, the department shall immediately endeavor to eliminate the unlawful employment practice. And, hey, here's when you can sue over it, is very much suggestive of letting the party know what the state thinks is wrong. Now, Activision could be lying here. Activision could be eliding what California actually told them. We have to use their statement with the same grain of salt we apply to the actual complaint in the state of California. But if California just blanketly refused to tell them what they were seeing, it's very difficult to read any kind of mediation as made in good faith. They were required by law to adequately investigate and to have good faith discussions with us to better understand and to resolve any claims or concerns before going to litigation, but they failed to do so. Instead, they rushed to file an inaccurate complaint, as we will demonstrate in court. We are sickened by the reprehensible conduct of the department to drag into the complaint the tragic suicide of an employee whose passing has no bearing whatsoever on this case and with no regard for her grieving family. While we find this behavior on the part of the state to be disgraceful and unprofessional, it is unfortunately an example of how they have conducted themselves throughout the course of their investigation. It is this type of irresponsible behavior from unaccountable state bureaucrats that are driving many of the state's best businesses out of California. Okay, so as we talked about before going into this particular statement, it is understandable if you are a company who feels that you are being railroaded and that specific bad Apple data points are being picked up by the state to be angry about that. It is understandable if you are in fact being railroaded to make statements like this in back rooms between your C-level executives at your company. It is not, perhaps, as we talk about messaging so often in this space, the best idea to go out with a direct attack on the state of California. My tonal recommendation would have been something along the lines of saying how important it is, of course, for the state to try to stamp out these bad policies and how important it is to be good industry actors, but that you disagree vehemently with what the state has found here and with the complaint, and you'll prove it in court, as they do a little bit better earlier in the statement. When you finish out with, this is why everybody's leaving California, you kind of lose the high ground of what you're trying to say, and I think a lot of people are going to ignore you because a lot of what the state of California has alleged looks so bad. Your objective, if you're Activision, is to try to establish that it's not as is described by the state of California, that there are bad actions, that it's not systemic, that these things happened in the past or are lies. Those are all fine. But when you get down to this is a witch hunt against Activision, this is why so many other companies have left, even if it's true, even if you believe it with your whole heart at Activision, you probably don't want to go out in this way because it looks terrible to anybody that isn't already on your side. The picture the department paints is not the Blizzard workplace of today. Over the past several years and continuing since the initial investigation started, which was, I believe, 2018, we've made significant changes to address company culture and reflect more diversity within our leadership teams. We got your complaint. We've tried to address it. We've made steps to address it. This didn't need to escalate to a lawsuit. We're back on a normal kind of statement playing field from this middle paragraph. For example, we reward and compensate employees based on their performance, and we conduct extensive anti-discrimination trainings, including for those who are part of the compensation process. A generalized kind of meritocracy defense here. And
it's like someone wanted to have that. That's why businesses are leaving.
Because the state of California
in
their lawsuit kind
someone
of
wanted
skips
to
over
put
what
that
a
in there.
counterpart is, what equal pay actually is, says some good stuff.
Yeah, somebody wanted to put that in there.
In their anecdotes about somebody bringing in more revenue, somebody potentially doing more, and that kind of thing. But there's still an...
All right, I'm gonna stop it just right there because that's essentially the end of everything that was said. Yeah. But, I mean, first off, you look at the plaintiff's complaint, the money side is weak. that's the way that this person explained it. Okay. And with him being a lawyer, granted from the state of Michigan, that is still still really weak. Okay. So
Yeah.
if that's weak, how much of a leg does the plaintiff have to stand on?
A lot, because of discovery, and that's what they don't want to show. They do not want to show their records. That's why this has gone forward, because they went to
Right.
mediation, or they were going to approach mediation, and Blizzard is like, no, we don't want to do anything. We're not going to discuss any discovery. We're just gonna here's a little lowball offer. That's probably all the mediation was. And then they just went, no, we're gonna go through, because we think we're not gonna admit any guilt. We're not gonna publicize anything, stuff like that. That's why I guess.
And if the lawsuit is structured appropriately, and the arguments are structured appropriately from the plaintiff's side, that should give the plaintiff at least some argument if this was to go to court to win. But it's like what you said. There's too many skeletons within the Activision Blizzard closet, some of which Activision probably doesn't know about.
Yes.
So
and that's exactly.
And they don't want that to come out. So
nope.
They'll be looking at money compensation. They referenced the Riot lawsuit, which was about $400 million.
Mm-hmm.
So we'll see if that number's comparable. I mean, that's going to be the problem there. We'll see what news comes out over the next few weeks about this, and maybe we'll have another episode of GQ2. I don't know.
Yeah, no, it's just really, when you have like the legalese behind everything and how it all plays out, I think that's where, it's going to be interesting, because, obviously this is going to go to the first round.
Yeah, and it will.
It's just going to be mainly like, the positioning now. But the damage has kind of already been done. So it's, from a Blizzard perspective, I guess I'm not sure what exactly they would do at this point, because the damage has kind of already been done.
I don't know, but still, that's that. I mean, this is a mess. This is a big, big mess. And now it's going to be up to lawyers to, figure it out. How does this go on? How do we fix this? Mm-hmm. And now it's going to be up to, after that, Activision Blizzard to figure out, how do we keep this from happening again? I mean, one thing, you ban alcohol from the workplace. I guarantee if you do that, Gulvan, if you do that, a lot of stuff's going to change. I mean, this is just horrible. This is just horrible shit. That's all it is.
No, definitely. And yeah, I mean, we'll have to see how it plays out, though.
Yeah. So we'll see what happens. We will try to keep everybody informed, obviously, because that's going to be, I think, part of the group quest job for now. That if something big does come out, maybe we can hook up a show or something. We'll figure that out at some point. But for now, this has been GQ2. That has been lawsuits, and like I said, this is just a mess. So hopefully next time we'll come up with something better. Just not.